Friends, property disputes form a major part of litigation in India. In most cases, the real problem is not ownership, but wrong documentation at the right time. People frequently ask, should I make a will? Is a gift deed legally safer? Can a release deed permanently settle family disputes? Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today, I will explain will, gift deed, and release deed in a clear, comparative, and practical manner, so you can understand which document is legally appropriate for your situation. Part 1. What is a will? A will is a legal declaration by which a person expresses how his property should be distributed after his death. Under the Indian Succession Act, 1925, a will does not transfer ownership during the lifetime of the person making it. The beneficiary gets no vested right, only a future expectation. A will operates only after death, is fully revocable, can be modified or cancelled any number of times, does not require compulsory registration. Courts have consistently held that a will speaks only from the death of the testator. However, wills are frequently challenged on grounds such as undue influence, lack of mental capacity, suspicious circumstances. In many cases, probate proceedings are also required, causing delay. Therefore, a will is best suited when the owner wants flexibility and control till death, but it carries a comparatively higher risk of dispute. Part 2. What is a gift deed? A gift deed is a legal document by which a property is voluntarily transferred during the lifetime of the owner, without consideration. As per Section 122 of the Transfer of Property Act, 1882, a gift becomes valid only when it is voluntary, it is accepted by the donee, it is registered. Once a gift deed is executed and registered, ownership transfers immediately. The donor loses all rights. The donee becomes absolute owner. The Supreme Court has clearly held that a validly executed gift cannot be revoked, except in limited circumstances permitted by law. Stamp duty is compulsory and usually higher, though concessional rates may apply for close relatives depending on state laws. Thus, a gift deed is ideal when there is complete trust and the intention is immediate transfer, but it also results in permanent loss of control. Part 3. What is a release deed? A release deed is executed when one co-owner relinquishes his lawful share in favor of another co-owner. It is important to understand that a release deed does not create new rights. It operates only where the releaser already has a legal share. It is commonly used among siblings or legal heirs. A release deed operates immediately, requires compulsory registration, is irrevocable, generally attracts lower stamp duty than a gift deed. Courts have clearly held that a release deed is valid only among co-owners and cannot be used to transfer property to outsiders. Therefore, a release deed is most suitable for family settlements and for avoiding partition suits. Part 4. Comparative legal analysis. First, regarding when rights take effect. A will operates only after death, whereas a gift deed and release deed operate immediately upon execution and registration. Second, regarding transfer of ownership. A will does not transfer ownership during lifetime. A gift deed results in absolute transfer, while a release deed merely relinquishes an existing share, enlarging the share of the remaining co-owner. Third, regarding revocability. A will is fully revocable. A gift deed and a release deed are generally irrevocable once registered. Fourth, regarding registration. Registration of a will is optional, but registration of gift deed and release deed is mandatory for legal validity. Fifth, regarding stamp duty. A will is the least expensive. A gift deed attracts higher stamp duty, whereas a release deed is comparatively economical, especially in family arrangements. Sixth, regarding litigation risk. A will is most prone to challenge. Gift deeds and release deeds significantly reduce future disputes by settling ownership during lifetime. Finally, Regarding scope, a will and gift deed can be made in favor of almost anyone, but a release deed is restricted only to existing co-owners or legal heirs. Part 5. Which document is perfect? There is no single perfect document for everyone. The correct document depends entirely on your intention. Choose a will if you want control and flexibility till death. Choose a gift deed if you want immediate and final transfer. Choose a release deed if the property is jointly owned and family settlement is required. Practical legal advice. Emotional decisions often lead to legal disputes. Wrong document can create lifelong litigation. Stamp duty and registration must be verified. Document must match intention. Legal consultation before execution is essential. Conclusion. Friends, most property disputes arise not due to bad intentions, but due to wrong legal documentation. A correct document at the correct time can protect generations. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.